When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful,
no matter how minute
this right, no matter how minute.
He who comes to equity must come with clean hands. Hello, you're welcome to another fresh episode of the program Justify Nigeria on ACNN Television, reaching you from Abuja. On today's episode, our topic will be the legal concepts of admission and confession, part 2. My name is Anozechi, and I'm so your uncle. The concept of admission and confession in the law of evidence is very crucial and fundamental. This is because the fulcrum and the success of any adjudication in a court is dependent on the relevance of evidence. In one of our previous episodes, we deliberated and explained what admissions and confession is all about in the law of evidence. However, there seem to be a lot of issues to be clarified in this regard. What are those issues? How can we identify those issues? How can we apply them in order to make them beneficial to us? With me in the studio to make sense of it all is Barrister Patrice Akwara. He is a public opinion analyst and also a member of Unity Bar here in Abuja. You are welcome to the program, sir.
Thank you very much.
One of our previous episodes, you really dealt well on what admission and confessions, what it's all about. But now we just want to take it a step further to understand certain issues and basic principles. Now, based on the early explanation, what are the types of admissions that we have? Type of admission. You can also make a little reference of what admission and confession are, just in a nutshell, then before you can now answer the question on the types of admissions we have.
Okay. Well, like we captured last time, admission, simplicity, or strictly speaking, is simply, when allegations are made, or just like, in litigation, you have either criminal or civil procedure. So in civil procedure, when pleas are made, the plaintiff will put down what he wants the court to grant to him, and will, state his own issues as in by way of pleadings. You understand? And then we'll revert back to file it, and when it gets to you as the defendant, you will look at it, like I said last time, answer them seriatim, one after the other. Anyone that you feel is correct, you admit it. You understand?
Yes.
Good. That's what's called admission. And let me just answer the question straightforward by both summarizing and going straight to what you're saying. There's what we call formal and informal admission. When you
are talking about the types now.
Yes, okay. Exactly the types. Okay. When you say yes, they are always put in paragraphs.
Yes.
You can say paragraph 1, to the extent of this, yes, we admit. You understand? Anyone you jumped or you didn't say anything, it is deemed as if you have informally admitted it.
Okay.
The ones you admit by saying yes
is formal.
Is formal. Then the ones that you jumped, because in law, in evidence, any pleading or any of those allegations that was alleged against you, which you did not controvert, that is to say, you did not answer to. If you did not lead anything against it, the court will deem that
you have admitted
it.
Oh, they will not dispense of it?
No, they won't dispense of it. Although they may not use it against you to say you are guilty, they will still expect the plaintiff to lead evidence to support their pleading, to support what they have written. You understand? But because you did not respond to it or controvert it, whatever they say, the court will likely believe them.
And you cannot say anything otherwise, because you cannot say anything about it.
You didn't say anything, because in civil cases, the principle is on preponderance of evidence.
What do you mean by that preponderance of evidence?
Preponderance of evidence is simply, let me give you an example with that blind lady.
You push logo.
Yes, exactly. There's like a scale. When you put something here, and then you put another thing here, the scale balances.
Yes.
But by the time they put something and there is nothing you kept, you put in the other one, it will tilt. So that's the preponderance. It preponderates here and there. So by the time the plaintiff will bring his evidence, will bring all his pleadings, and all those things, they will say you did and you did not do. They say you did and they bring it there, and you were not able to counter them either by an affidavit or whatever, or pleading, leading. You didn't put anything on your own scale, because there are two parties. It's either the plaintiff or plaintiffs, as the case may be, they are still one party, or the defendant or the defendants, as the case may be, they are also one party. So those two scales, each of them will take those scales. So what you bring, you understand, will determine where that scale preponders. Exactly. So,
and of course, the one that weights more.
It's on preponderance of evidence. What they put there is evidence. So that is how the court.
But it's not the same in criminal.
No, in criminal is
beyond all reasonable doubt.
Beyond all reasonable doubt. As they are saying, in criminal is the state against any accused person. So when the state, through either the police commissioner or the IG or the attorney general, brings you to court by way of criminal charge, the onus of proof is on them to prove the case beyond every reasonable doubt. What that means is that whatever they are bringing, there is a reasonable doubt that you didn't do it. And that is when you, the accused, through your counsel, will always, good lawyers will only be putting reasonable doubt to whatever they are breaking. They just bring it. You may say, he killed somebody by 3 p.m. in Kano. A good lawyer will not even go to he will just say, but at 3 p.m. he was in Lagos. He has brought a reasonable doubt. That's enough. If he has brought a reasonable doubt, if he is able to prove that he was in Kano, the reasonable doubt has really cast a lot of reasonable doubt towards it. So the judge will now weigh it. That's simplicity.
Thank you very much.
The rest is too much. Legalese.
Just like what you said, the types of admission is formal and informal.
Exactly.
The one you now openly, as said, that one is formal. But once you jump them or you don't say anything, it's being deemed, and that is informal.
Yes.
Thank you very much. Now we usually am about oral evidence, documentary evidence, and what have you. Can you explain to our viewers what those things mean, the oral and documentary evidence?
Okay, thank you very much. As it is, law is, you don't learn law with we are a common law country, Nigeria. So you learn law with English. You don't learn it with Igbo or Yoruba. So what it means, anything they say, first and foremost, try to understand it, the English, the dictionary meaning of it. As a layman, I'm just talking to all of us as lay people. Maybe if you're a layman, listen to me. They say oral evidence. It means statement, verbal, things just said, oral. The evidence you're bringing is you are going to use mouth to say it. That is what oral evidence is. So all the litany of evidence you are going to bring is the one they ask you in court, the statement you make. And oral evidence is very, very important because these ones are the ones you are saying and the judge is looking at you. He is looking at you, looking at your demeanor.
He's putting on something.
He is looking at you, knowing gauging whether what you are saying it truthfully or you are lying. Because you will be led in chief by your own lawyer and you give all those
Yes, what do you mean by examination in chief? I was about to ask you that. What do you mean by leading chief?
Being led in chief to be examined in chief is when your lawyer, your own lawyer will call you to this, when you come to the stand and he'll ask you questions.
By your own lawyer?
By your own lawyer, not the other lawyer. Okay. And you say the thing, he will ask you to say the things you know about this case. That he's not cross-examining you, he's not putting hard questions on you. Okay. He's inviting you to say what you know about this matter. So he will just lead you, he will start preliminary by asking you your name, all those things you know.
That is examination in chief.
Yes.
Then there's one you call like cross-examination.
Yes, cross-examination. The way it sounds, cross, they will put leg. They will put leg just crossless. So
you can coming from the other party.
The other party, yes. So that they will ask you, they will tackle you with all kinds of questions.
Okay.
And all these things you are saying are oral evidence. Because you are saying it and the judge is looking at you, looking at your eyes, looking at how you pause to answer, looking at whether the one you answered before it corresponds with the one you're answering now. So he's checking all those things. He's really watching you to know whether you are a witness of truth or a witness that cannot be relied on.
Then after that cross-examination is what you call re-examination.
Yes, re-examination. Fine, after the cross-examination, like we said, the examination in chief is when your own lawyer asks you. Then the cross-examination is also when the other lawyer, the opposing lawyer, will ask you certain questions. Okay. Maybe in making all those comments under cross-examination, giving your evidence on that, there are some gray areas, some things you said that made it look as if the one you said earlier was not correct or not truthful. So your own lawyer will now come and re-examine you in order to straighten all those things. Dot all the T's, dot all the I's and cross all the T's to make sure that in the eyes of the judge, you don't look like a liar. So he just iron it out for you.
Examination in chief, cross-examination and re-examination are some part of oral evidence. When we come back, our guest is going to talk about the documentary evidence. Please do join us again. Hi, you're welcome to another segment of The Speaker, reaching you from ACNN Television here in Abuja. On today's segment, we are going to be looking at the particular question whether we are living on a venerable Nigeria or a vulnerable Nigeria. My name is Anozie Chinomso. The word venerable is usually and often referred to one who is worthy of veneration or reverence, deserving of honor and respect. This means that when an individual or nation is proudly honored, such person or nation is automatically a candidate of veneration. On the other hand, vulnerability exists when one is capable of being wounded, susceptible and liable to injuries, and assailable to hurt, attack, and probable destruction. With the kind of disintegration and dilapidation going on in Nigeria, I'm persuaded to ask on whether we are living in a venerable Nigeria or vulnerable Nigeria. In a situation where the late Chief of Army Staff died in a plane crash, barely few months of assumption of office is a typical example of a vulnerable Nigeria. In a situation where the burial of an army chief of a country was not graced with the presence of a president is an affirmation that we are living in a vulnerable Nigeria. Where the remaining kidnapped students of Greenfield University were released, and over 200 students of an Islamic school were kidnapped on the same day at Tegina local government area of Niger State is a clearer pointer to the fact that we are living in a vulnerable Nigeria. In a situation where the state CID was completely razed down with fire by unknown gunmen and police inspectors killed, showcases that we are operating in a vulnerable Nigeria. INEC office being razed down with the fire by the same bandits in Njaba local government or area of Imo State, Nasarawa state lawmaker being kidnapped by gunmen, immigration office at Obakala in Abia State being razed down by fire, 10 suspects of online drug traffickers being arrested, points towards one direction: the vulnerability of Nigeria. Is it not worrisome and frightening that a former judge of Enugu State High Court by name Honorable Justice Stanley Naji was assassinated at the Garden Avenue in Enugu State on Sunday afternoon, 30th May 2021, by unknown gunmen who pulled him out of his vehicle, shot him dead, and drove away with his vehicle? When the assassination of a 67-year-old Professor Goswill Obioba, the NECO registrar, was reported that he died after a brief illness, is another example of a vulnerable Nigeria. This is most laughable. A situation where Rwanda launches first smartphone factory in Africa, and Nigeria is still searching and debating where cows will sleep comfortably in the 36 states of the Federation, including Federal Capital Territory, is a very good example of a vulnerable Nigeria. How can Nigeria be this porous? How can it be that Nigeria is no more a safe country? How and when did we get here? How can we explain a situation where a governor of a state was seen dancing in a ceremony and subsequently traveled abroad, and his state is in a state of disarray and pandemonium? Nothing bothers our political leaders at all. They have forgotten so soon the oath they took to protect the lives and properties of their citizens. They have forgotten so soon all the campaign promises. How can it be that in all of this that has happened and is still happening, our dear president have not spoken, let alone addressing Nigerians? The question is, will Mr. President eventually speak? The question is there any other country called Nigeria except this one we are destroying? The question is, where do we run to if Nigeria is completely destroyed? I think time has come when our president should rise up and speak to his people. I think time has come when Garuba Shehu and Femi Adesina must know that they are not the president of Nigeria, rather spokesmen to the president. In order to justify Nigeria, I therefore speak. Until our leaders begin to see that we are all sitting on a keg of gunpowder that will eventually explode if the proper thing is not done, and thus begin to drastically checkmate this crisis happening all over the country and quickly proffer solutions so that peace, love, and unity will reign, and further realize that we all are one and we deserve to be treated equally so that nobody will feel marginalized, we shall continue to have a vulnerable Nigeria instead of a venerable Nigeria. My name is Anozie Chinomso, and I just want to speak. Glad to know you are still there with us, and we are still here in the studio with Barrister Patrice Akwara. Counsel, before we went on break, you have explained very well on this oral evidence. Now we're talking about documentary and real evidence. What are those things? Yeah. Having done well in oral evidence, now what are those things?
Yes, just like I said, that whatever, anything, any jargon you hear in law, any legal term you hear, so long as it's English, go to your dictionary first and foremost and check. There must be a relationship, a meaning between what you heard and the dictionary meaning. The rest is just gray area with the lawyers, except it is a Latin maxim or Latin word. So as the name documentary evidence connotes is just document the evidence you bring in form of paper, document written. It could be written something you've made, you've written, or it could even be in a book, written, whatever is documented. But there is something, I have to make this statement. What makes evidence admissible in court mostly is what we call relevance under the Evidence Act.
That means not all evidence are relevant.
Not all evidence are relevant. Okay. As you want to tender any form of documentary evidence, the court will, if the other party opposes you are presenting that document, you will have to, through your lawyer, show cause that evidence you are seeking the court to admit in evidence is relevant. Relevance is at the root of any documentary evidence, any evidence you want to bring, because the court will look at it. So what I wanted to say in saying this is that any document you make, documents that are admissible should be documents that have already been in existence or part of the issue in court. Any document you make after the events have happened may not be admitted. Or any document you make also preparatory to your defense. Let me give you an example. We're talking about a book. A book, you said, he stole my book. And you now find it in his custody, and you want to show that this book belongs to you. Meanwhile, that book you are alleging that the defendant, the accused, stole it. But that book doesn't have a name written on it. And the accused person also has a book like that also. And his own, he didn't write any name. Now, eventually, when this book was discovered in his custody, you are claiming that it's your own, and then you have it. Maybe you go behind and write your name on it. You have prepared to sway the court's idea that you are just preparing for a court case. It may not be a very good experience. It may not be a very good example, but you have created an evidence after you allege that he stole your book. So any evidence you create in contemplation of litigation, or when the litigation has started, if the other party shows the courts, no matter how relevant that may be, you understand, if the party it will be inadmissible. So it's important to really understand that documentary evidence are evidence, in documents. As
is it something with real evidence?
No, real evidence is just real, the things you are seeing.
Just like you said, the name.
Yes, just the name, yes. The things you are seeing. It could be a book also, it could be a car, it could be all those things. Somehow when they are admitted, they become exhibits. Yes.
Okay. Now we talk about the evidence. Oftentimes, does evidence necessarily needed to be front-loaded? Evidence must they be front-loaded in a trial?
Yes, under the civil procedure.
First of all, what is front-loading?
Front-loading.
So that's
okay, front-loading.
Now.
Front.
We talked about this English word and jargons and others. What is front-loading?
Yeah. Front and loading. So that's the way it is. Putting something ahead.
Okay.
Just putting it ahead. And I think it was the Lagos Judiciary, the Lagos Civil Procedure that really started this in Nigeria.
And now it's now universal.
It's now universal, yes.
They did well.
Yes, they did well. I think, yes, it was the Civil Procedure Act of Civil Procedure of 2004. That was when this novel, front-loading principle came up. That is to say, you as the plaintiff, when you are filing any matter in court, part of your pleading, part of all your statement of claim should contain the list of the evidence you intend to plead in court.
In civil procedure?
Yes, in civil procedure.
Okay. All of them?
All of them, you have to put the list, including the list of witnesses you intend to call.
Is that serious?
Yes, serious. That's serious. You have to put all of them. If you intend to use a letter of offer of employment, or a letter of admission, you need to tell the court that you are intent to, so that by the time you file it, part of the processes, all those pleadings, all those statement of claim, part of what we serve the defendant will have an idea of how you, the plaintiff, intend to plead, to come to court against him, so that he can also prepare. And this is fundamental because it is part of the constitutional provision. I think one of the sections of the Constitution, it says that every person charged to court or brought to court must be given opportunity to defend himself. Reasonable time to defend. So you must front load, or you must show how you intend to, pursue your case in court, so that you don't do what we call ambushment. You don't lay ambush. You don't just take somebody by surprise. Because when you take him by surprise, and maybe he's found guilty, you've not secured justice. You've not secured justice.
That's the essence of law.
Yes, the essence of litigation, the essence of court is to do justice, because both the plaintiff and the defendant, they require justice. And it is the court's responsibility to give it to them.
Okay, and that's what for them is for what you're saying, that in a civil matter, evidence must be front-loaded.
Must be front-loaded.
But what about that of criminal?
Yes, it's also there. It's just that the police, in practice, they will not tell you anything.
Oh, yeah, in practice.
In practice, they will just come there and be asking you questions. They never told you anything.
Exactly.
So what we do, when they do it, we seek adjournment.
We seek
adjournment so that you can prepare yourself. So viewers, when you see that court cases drag for many years, it's because this is part of it. Because you can't just come to court, you didn't tell me what my client did, and you just bring one thing and say he did it. I will tell the court, my lord, my constitution guarantees that my client who has been charged, who is an accused in this matter, either for murder or for anything, should be given reasonable time to carry out his defense. My lord, he cannot provide any answer. Please give us a short or a long adjournment, as the case may be.
Thank you very much.
And the court will always grant it.
That one. Your last word to our viewers in terms of your advice before we go. Less than a minute.
Good. Well, part of the problem and the solution to it, I'm a solutionist. I like giving solutions to problems. Is feel free to always have a lawyer. It is important that every family, in fact, every person doing business, even if you are selling pure water, you should have a lawyer. When you have a lawyer and you are entering into a business transaction with somebody, that person, the chances of litigation coming up in future will be highly minimized, because the lawyers in that arrangement, in that contract you intend to enter, will ensure that things are done according to the law of the land, or according to the law governing those transactions. Families should also have lawyer. If there are families, a lot of families, like by His grace, I'm a lawyer to a lot of families in this country. So any little thing, maybe when they even want to buy one thing or the other, they want to do all this, the consult, and you can seek your lawyer's advice informally. You don't have to pay him money at that time, maybe. But if the matter reaches to the extent of but as you have to have a lawyer, because part of the problem we have in this country, and that's why the police and the government take us for granted, is because they feel we don't know.
Our rights.
We don't know our rights. Yes. So your lawyer will always be there to guide you, to talk to you. But it's also important in engaging with the police and government. You also have to be civil, because most of all these civil rights abuses, because maybe they will tell you to stop, you don't want to stop, and you move and they will shoot. Or just like some cases overseas, you see they will state, especially against black people, they will tell them, you're under arrest, they want to run, they start shouting at them, start talking to police, those things in an uncivil manner, all those things are infractions against the law. A police officer is supposed to be your friend, and whatever instruction he gives, you should comply. You should comply, and then when you comply respectfully, he will also give you back your respect.
Thank you very much. Respect the authorities so that authorities will also respect you. We've heard it all from Barrister Patrice. I want to appreciate you for coming.
Thank you
so much. And I pray how busy your schedule, no matter how busy your schedule might be, when next we call you, please still find time to oblige us.
No problem.
Thank you very much.
Thank you, sir. Appreciate it.
From our discussions, it could be seen and believed that it is totally impossible to succeed in any matter in court without an evidence. It is also a factual fact that no judge will base his findings, rulings, orders, and judgments on sentiments and speculations. In fact, I dare say that the court will be legally incapacitated in adjudication when there is a matter before him without the presence of any evidence. It is therefore advised that litigants, especially their legal representatives, must do the needful on sourcing a concrete and relevant evidence in order to prove their cases. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, my name is Sanoze Chinomso. You to bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.